SJC-12814, Commonwealth v. Debonair Beverly. SJC-12815, Commonwealth v. Andrew M. Rossetti. SJC-12816, Commonwealth v. Marlana L. Ellsworth.
Good afternoon, Your Honors. May it please the Court, Megan Rose for the Commonwealth. With me today is Assistant District Attorney Jean Kempthorne. The facts before us show that on 3 separate occasions, the trial court purposefully and blatantly intended to undermine the Commonwealth's authority to prosecute cases by continuing cases without a finding and immediately dismissing them with no attached conditions.
Did you walk away from the Article 30 argument?
Yes, sir.
You have?
Have I walked away from it?
Yeah.
No, I have not. I believe that it doesn't need to be decided by an Article 30. I think that the statute is clear. It's a statutory interpretation. But I do believe that there is an Article 30 argument to be made.
So if the judge had said, this is a quaff, he must not commit any crimes, and for the next day and tomorrow it shall be dismissed, is that forbidden?
I think under the statute, I think that there has to be some meaningful time period between the crime, the charged offense, the offender, and the conditions placed. I don't think that this court needs to set a floor or a limit. I think that there has to be a coherent connection between all 3 of those things.
Do you think the 4 o'clock afternoon is something that is permissible?
In that case, I do not believe it. There's no condition.
Well, what if he had put some conditions on, go have some coffee, don't commit any crimes, come back at 4?
And no, I do not believe that that would have been appropriate in this matter.
In a word, it can't be a gag, right?
No.
Right.
4 p.m., practically speaking, when he says quaff 4 p.m., the defendant doesn't go over to the probation table and do any sort of probationary intake.
Well, as long as we're talking practically speaking, when a case is continued without a finding, the idea is, well, there's enough evidence for a finding of guilt. Some judges actually require the guilty plea as opposed to admission of sufficient facts for many reasons. And the judge nonetheless decides that they're going to continue the case without a finding for a period of time to see what happens and whether or not it really, even though there's enough for a guilty finding, there's a plea of guilty or admission of sufficient facts, the case is going to be dismissed. That's the whole point of the quaff in the real world, right?
Yes, Your Honor.
And when you continue it without a finding until 4 o'clock, the whole point of a continuance without a finding, having done hundreds and hundreds of them, is lost.
Yes, Your Honor.
It's a pretend continuance without a finding. It's a dismissal.
Yes, Your Honor, absolutely. There is no meaningful time period for the defendant to have earned his dismissal. It is just, there is no, why would the legislature call it a continuance? There is no continuance for what? For what purpose? We should call it what it is a dismissal.
Right. It's a continuance to see if this crime that was committed, this person really, considering everything, if they can stay out of trouble, shouldn't really have a criminal record.
Yes, Your Honor.
It's not to say, oh, well, here's a good way to get around Article 30 because I don't like this B&E prosecution, so I think I'll dismiss it at 4 o'clock.
Absolutely, and that's what he did in this case, and that's what he did in the other case as well, where he states that, this one was wildly overcharged, and the next one, oh, I'll spare you the felony in both of those cases. And the same can be said for the 3rd case, the Marlana Ellsworth case. That judge in that matter, quaff dismissed every single charge except for the simple assault and battery charge.
So what is a meaningful period of time?
I think a meaningful period of time will depend on each individual case.
That doesn't give much guidance to the judge, does it?
Well, I don't believe that the language, I think that the language of the statute is clear. The Commonwealth's position is not saying that the judge still doesn't have discretion in sentencing. They absolutely do, but discretion has boundaries, and in this case, he has to provide some kind of meaningful time condition some meaningful time period and condition that is equivalent to the offender and the crime charged.
It could be sufficient to satisfy whatever conditions are imposed, right? So if a judge said, I'm gonna continue this for a day, and tomorrow you're gonna write a certified check out and pay Mrs. McGillicuddy for the fence, that could be a condition, right? That takes a day.
The Commonwealth would agree, yes, that would be sufficient in that matter. That it depends on the facts of that specific case.
Or you're gonna apologize to somebody. I mean, it's gotta be something.
Some kind of condition to show that you've earned your dismissal.
For instance, I think maybe in Berkshire County, there's a lot of effort, which makes sense, to have some sort of restorative justice. And sometimes there's a restorative justice aspect to a continuance without a finding that really doesn't require a heck of a lot of time, but it's important.
Yes, Your Honor.
And so maybe that's not a long period of time for some sort of restorative justice meeting.
Absolutely. I believe that, as I previously said, I don't believe that this court has to determine that there's some kind of minimum time period or floor. It has to do with the crime, the offender, the conditions attached, all in this coherent circle.
And how about probation? The person can be placed on probation,
Yes, Your Honor.
and probation under Section 87 can be for such time and upon such conditions as the judge deems proper. So the judge has discretion in terms of the length of the probationary period.
Yes, Your Honor.
But you're saying that at some point it's an abuse of discretion if it's too short?
Well, no, Your Honor, I don't believe that. I think that, again, probation, under the statute and case law states that probation has to have some kind of deterrence, some public safety, some retribution, and here, the judge has the discretion to determine what would be that meaningful time period with the crime charged.
But what if the judge says it's administrative probation,
That would,
not supervised?
that's fine, Your Honor. That would be fine, Your Honor.
So I'm just trying to, so if you're right, we go back and the judge now has to decide for a quaff, how long is long enough for probation? I understand Justice Gaziano has identified some specific terms and conditions, but there's that second provision. What's the guidance we give to the district court and the BMC about how long probation must be for it to be viewed as a meaningful?
Even under probation, there's, do not commit any crimes. There's the certain conditions that they have to abide by under probation. And I think even with, it would have to depend on the facts of the case and the offender.
If it's a minor case, it could be a week?
Perhaps, Your Honor, yes.
Okay.
It have to be some kind of meaningful time for them to have earned that dismissal, that they can take their conduct and conform it to the law to show the judge that they should have that dismissal.
So pragmatically, if as in these cases, the person had already served time and you wanted to give a time served adjudication, there'd have to be a guilty finding.
It would have to be a guilty finding.
But is there something a bit weird to say, well, if you want to give essentially no additional punishment, you have to find the person guilty and do a time served, but you can't do a quaff and effectively a time served, which is what the judge basically did here.
In the Beverly case, defense counsel had stated, I'm not asking for a quaff on this case because I don't believe that my client can pay any fines. Essentially indicating that they also know that some kind of fine or condition or probationary term would have been required for a quaff. But there's a difference between a guilty finding and a quaff in that, just because someone did time served already doesn't mean that the guilty finding on their record would be different than a quaff on their record, clearly. Does that answer your question?
Right, I understand that, but it's sort of, I'm just wondering, I mean, you have a case in which a judge basically says the person's already served enough time, and I think it's appropriate for a continuous without a finding. What you're saying is basically then for the judge to do that, the judge would have to make a guilty finding, because if there were to be a quaff, there'd have to be some additional sanction above and beyond the time served.
Yes, Your Honor.
Isn't there something counterintuitive about that?
I don't believe so. I don't think we can call a time served. I think you have to have the distinction between the time served in a case and a quaff and an outcome. I mean,
Could you
I'm sorry, go ahead.
Could you file without a change of plea to get away from the guilty finding?
Could you file,
File the charge without a change of plea to get rid of the guilty finding?
you could, like a guilty file charge?
No.
Filed without a change of plea, a separate disposition?
Okay. And that would get rid of the guilty finding?
You need the
without having been-
Commonwealth's consent for that.
And in certain situations, the Commonwealth could consent to something like that. But I think we have to go back to the facts in these cases. I think that in these cases, it's very clear that what the judge intended to do was to override the Commonwealth's authority in prosecuting the matters.
It still raises the problem. We got to scratch our head and figure out what are we saying to trial judges, because we don't want to say, well, you'll know it when you see it for how long the quaff has to be. I appreciate that you can't use the instrument of a continuance without a finding to change your role from a judge to a prosecutor. I appreciate that, but
I think that
how do we put some?
we already have case law showing that talks about a judge's discretion and the boundaries within a judge's discretion. Simply here, there was no discretion. It was outside the statutory provision. I mean, there's clear case law that says your discretion has to be articulate and punishment and deterrence and the public safety, and those case laws already exist. So I don't think anything with this case would change that, Your Honor.
Is Cheney still good law? I mean, in Cheney, we said for a quaff, you must do three things: identify the date of the dismissal, condition the dismissal upon compliance with terms or conditions, or place the defendant on probation, and third, whether the Commonwealth objects, gives reasons on the record to ensure no abuse of discretion. Is that still good law? Cheney was 2003. It quotes Piles, which is earlier.
I believe that Cheney is still good law. That's the one that overruled essentially the Brandano decision that you couldn't do the pretrial probation anymore and then dismiss. Yes, Your Honor, I do believe so.
So here, the judge did not give reasons on the record, even though the Commonwealth, at least in one case, objected. I don't think it objected in all the cases.
The Commonwealth did not object in 2 of the cases. Our position is that the Rule 29, the procedural issue, would have been our objection in those cases.
But is there a consequence to the Commonwealth not having objected at the time? Because then the judge didn't have the opportunity under Cheney to give his or her reasons.
I think under Pliles, which I think is actually before Cheney,
It was.
and I think there, regardless of the Commonwealth objecting, they still have to give their reasons for why entering a quaff disposition is appropriate in this matter. The fact of the matter is the Commonwealth wasn't in agreement with any of the quaffs to begin with. We had guilty findings we had requested guilty findings at sentencing.
So you're saying the mere fact that you didn't ask for it is sufficient to obligate the judge to give an explanation, even if there's no objection to it?
I do believe so, but I also think that our objection also was under the Rule 29 in 2 of the cases.
It was done after the fact,
After the fact,
about 58 days, or at least for one of them.
for one of them was, yes. Yes, Your Honor.
Okay, so going back to Justice Lowy's question, which is the fact that we have to spend time with BMC judges and district court judges, and they want us to know what we're asking them to do when they want to give a very brief period of time to give a quaff.
I think
What guidance would you say we should give them?
having some kind of record to show that they used their discretion and it was appropriate. As I previously said, there are cases on point that show what if a judge abuses discretion in sentencing. And if their reasonings are on the record and it's appropriate considering the time, the conditions, and the offense, it wouldn't be an abuse of discretion. And it would be in conformity with the statute. Are there any, I'll briefly touch upon the Rule 29 issue. The Commonwealth's position is that the Rule 29 is the appropriate avenue to challenge this disposition. The majority in Rossetti stated that Rule 15 was the appropriate avenue. Rule 15 is impractical and for many reasons. The 3 cases cited by the majority, indicate that those cases were dismissed because the sentence had already been served. In
But
this,
isn't that the same thing here, though? If the case has been dismissed, are you saying that Rule 15 does not apply, or it's not the best rule?
Rule 15 we could not use Rule 15.
Because,
Because our case is already dismissed, the case would be moot.
but isn't that the case for any case that's been I mean,
Well, Rule 29 allows you with those 60 days.
no, but I mean, Rule 29, I mean, Rule 15 is for cases that have been dismissed, right?
Dismissed pre-trial. This is not a pre-trial dismissal. We have, it's after the plea, and the case is moot. And so Rule 15 would not be the appropriate avenue. Rule 29 would be the appropriate avenue.
You'd have to apply to the judge to revise and revoke, saying, Judge, this was an illegal sentence.
Yes.
The judge who just did the sentence.
But I think practically speaking, that's what the amendment to Rule 29 was meant to do, to quickly rectify any illegal sentencing errors.
Right, I get that, but it's kind of, I don't know how effective it's going to be, but go.
If we assume Rule 15 did apply, you would have to go through the single justice to get permission to appeal, is that correct?
The Rule 15 would be the gatekeeper? Yes, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Ms. Chayette.
Thank you, Chief Justice, and may it please the court, Kara Chayette on behalf of the three individual defendants. If I can start with Justice
All
Garcia.
right, before you just start with that, can you just tell me, you don't have a problem with saying that a quaff is a sentence, is that correct?
That's correct.
Everybody agrees?
You, on the Rule 29 part of it?
I agree that quaff is a sentence for purposes of Rule 29. I disagree that Rule 29 is available to the Commonwealth in these circumstances. And if I could, you just asked Justice Gassiano about illegal sentence, and I would note that that's the first time. This really is about whether this is an illegal sentence. Most of the questions and most of my sister's arguments are about the exercise of the judge's discretion. An illegal sentence is a very narrow concept, according to the reporter's notes, and typically it's a violation of Article 30. It's a clear violation of a statute, so it's a sentence in excess of what is statutorily permitted, or it is a sentence that is statutorily allowed. It's in excess of what's permitted, or it's a sentence that simply isn't prohibited.
This might be a chicken and egg thing, but if we found it was a violation of Article 30, it would be Rule 29.
Yes, I would agree. Yeah, then if there's a clear sort of drifting into the lane, out of the judge's lane and into the prosecutor's lane, or in terms of discretion, what's been described in the cases as an illegal sentence is when the judge has the discretion to consider certain factors, but declines to exercise the available discretion.
Says I'm bound by this. And,
Exactly.
Right.
And so those are really the three categories that you find. This isn't anywhere. To talk in terms of Justice Lowy's, your view that this is, in fact, an Article 30 violation, the prosecutor had all of that discretion to decide what charges to bring. Once the defendant pleaded guilty or admitted to sufficient facts, the executive branch had its pound of flesh. At that point, the authority shifts to the judiciary. Now, after the sentencing, that is, authority shifts back to the parole department. I mean, McCulloch is a case where the judge says, if the parole department 2 years down the road doesn't parole you, come back with your motion to revise and revoke, and because that's my intention, that you only serve 2 years. That's an Article 30 violation. You can't do that.
That argument is a good argument, and it resonates with me, but because when you, but I have a problem with it that I want to see if you can clear up nonetheless. And that's, you do a continuance without a finding. As a judge, you go through the whole colloquy. A victim may want to allocute. You make the findings necessary to be made, and it certainly feels like there's that shift that you just talked about from executive to judiciary. That really makes sense. But when the disposition is, I'm going to dismiss the case at the end of the day with the reason being that you think it's overcharged as opposed to any of these other reasons, then it makes me feel like there really wasn't a shift, but the judge is exercising an executive prerogative.
Well, so obviously we have three different cases, and there were three different kinds of reasons. In the Rossetti case, that's exactly what the judge said. But is it a violation? I was thinking about this in terms of property rights. I say to my sister, my goodness, you just built your fence right at the edge of our property, on your property, but right at the edge. There's going to be this sort of, if the executive is going to go out to the very outward bounds of its authority, for the judge to observe, you've really exercised that authority, haven't you? And I'm going to exercise mine with that same breath. I don't think that's an Article 30 violation. And in fact, if you, I know some judges like metaphors and some don't. I think in metaphor language, but I think
You're doing all right so far.
thanks.
Keep going.
But the legislature, I was thinking of the Cheesecake Factory menu. They've written this book, this code book that's so expansive. And the executive opens it up, and it'll take 4 appetizers and 3 entrees and 4 desserts and 5 drinks. And they may have a basis for that, but the judge is looking at a whole case with a whole suite of charges and can observe that seems, and the fact is that there is leverage associated with charging everything you possibly can. And the Commonwealth has the authority now under Rule 12, if they make a charge concession and there is an agreement, that they can actually eliminate the judge's authority to sentence, to find that that's too extreme and to go underneath it. So there's leverage that's associated with the charging decisions, and it can cabin the judge's discretion in certain ways. And I don't think, and there's no other remedy to, it's hard for me to believe. I was surprised that there weren't more cases that talk about the problem of overcharging. Maybe it's just sort of an open secret.
But that's
that it
discretion though,
happens.
right? Isn't it the remedy to run for DA?
I'm sorry, it's what?
Isn't the remedy to bang up some lawn signs and run for the district attorney's office? Because it's a legal, it may in a defense attorney's opinion be an overcharge, but if it was a charge that wasn't based upon the evidence, you'd move for dismissal, correct?
Well, yeah, but like, so in the Rossetti case.
Because it's the DA's discretion.
Absolutely, but it still can, I think for some judges, I mean, think district courts, and I know Justice Lowy practiced in the district court, but they're hyper-local courts. I mean, there's 60-some-odd district courts. Everyone is largely in the same community, and in that particular case, that it might feel, whether because of the indigency of the defendant who served a bunch of time that a person of means would not have been subjected to. Look at sort of the dynamics of the case. In the Ellsworth case, the judge was considering her employment opportunities. The victim of her assault spoke on her behalf. There are these various considerations that the judge should be able to consider and come up with a just result.
And that would work, assuming there were conditions and assuming it wasn't, as we've called it, a gag or a fake quaff. But there are also considerations the judge makes. I think it was the Rossetti case where the judge said he didn't see what the possible felony could be in that B&E. And he backed off, thank goodness, before going any further, because the guy's breaking into his girlfriend's house.
Yes.
So there's some valid considerations on the other side, too.
Oh, and I'm not suggesting, I mean, district courts, I guess I'm making a couple of points. One, district courts, very local. There are certainly significant crimes that get adjudicated in district court. But in that one, the prosecutor states the facts, and the defendant agreed to them. That question of intent, what was the felony that the defendant intended to commit once he got in, that probably isn't susceptible to a statement and facts. I mean, that sort of that intent aspect is something that would require a different kind of proof. I mean, that the facts as accepted by the defendant in their sort of bare bones way was enough to warrant the charge is I think a subtly different question, whether from the judge's perspective, hearing it all and trying to reach a just result, whether that's not an appropriate disposition. And I'd come back, I mean, I do think that it's really important for the court to think in terms of whether you're looking at the language of the statute in terms of how the discretion that is baked into the statute is exercised. That's not a Rule 29 question. If the question is, how should the judge tweak the conditions, now we're in an abuse of discretion area.
You mean
That's a
I mean-
211.3 issue, not a Rule 29 issue.
Oh, okay, I thought you, so that goes back to the question Justice Bud asked you about Rule 29.
So you're saying this does not come under Rule 29?
So my argument is, what I'm saying is that that's what the distinction I tried to draw, that yes, a quaff is a sentence for purposes of Rule 29, but the Commonwealth's right under Rule 29 is extraordinarily narrow. Rule 29 is itself, so is it illegal? Usually illegal violations of statute, there's a clear violation and there's a
But
clear way to make it right.
Who makes that decision? Because what we have here is the appeals court said, no, Rule 29 doesn't apply, and it came to us. And now it sounds like both sides are saying, this is a sentence under Rule 29, so do we not just send this back and say, you need to look at this under Rule 29?
No, because the Commonwealth can't use that to demand that, two things, that the judge exercise his discretion in a harsher manner. That's, I mean, even Solovka said, that's not when Rule 29, that's not a right that the Commonwealth has under Rule 29.
But we're now at the point, if you're saying that, no, Rule 29 doesn't apply because we're looking at 278, Section 18, right? Now we have to interpret the statute. So that's for us to figure out.
Yes, absolutely. I'm not making, so my first.
You're not conceding you don't think it's an illegal sentence?
I don't think it's an illegal sentence, and hence
You
the
think
Commonwealth
it's
has no right under Rule 29.
Original analogy. We
My
had
Cheesecake Factory?
No, we've got overcharging by the Commonwealth and we've got overjudging by the judges, but it's not really illegal judging. It's just
Well,
form over substance.
I don't think that either. I don't think the executive overstepped their authority.
I mean, I thought you made a very good, sort of informative, at least for me, informative. Okay, you've got a judge responding to what he thinks is overcharging, and he's responding cutely, but within his discretion.
I don't think it's cute, and actually, and I would draw the court's attention to my record appendix, in which it shows that the Commonwealth repeatedly requests this disposition. There are attached in my record appendix at RA 16, I put together a table, but following that, there are public records that I just randomly found where the Commonwealth has requested a same-day or a one-day quaff with or without conditions. I believe that this entire case is something of a turf war where the Commonwealth doesn't actually believe that it's an illegal sentence, but they only want it to be available to judges when it consents to it.
It's starting to sound like Brandano wasn't a bad case.
No, but part of the problem, and this goes to Chief Justice Gantz's question about Cheney. So let me do that one first. Cheney talked about the findings. Rotunda said many years later, no, we're not going to superimpose back onto the statute the written findings that Brandano said a judge had to issue. And in those, most of the statutes that require a condition of a quaff, those like 207A and 26513M give the judge the alternative of writing findings saying why he's not imposing the conditions.
But back to Justice Gaziano's point about the gag, the 4 o'clock thing is it's not real. It's just an excuse, isn't it? I mean, it's not 4 o'clock to pay so that you pay for the restitution. It's just 4 o'clock to game the system, isn't it?
I don't think so, because like in that particular one, let's talk Beverly. He'd spent actually, so 29 days on some of these charges, some of which the Commonwealth dropped that morning. He just spent 60 days on a shoplifting, dismissed that morning. And he was staying in custody until Friday. So this is on a Monday. He's in custody until Friday. Everyone agrees that he's staying in custody. And so the 1 day, a 2 day, a 3 day, a 4 day, I mean, I suppose I would agree that if you're going to dive into this discretion question, then certainly making it plain on the record to the defendant, even if he's not filling out a probation form, that you're bound by the standard conditions of probation. You know, or maybe this goes tomorrow, but is there any question in anyone's mind that if Beverly had been free to walk out of the courtroom and he kicked a police officer the moment he stepped out, that charge is not being dismissed at the end of the day? So I think there's sort of but to make that plain on the record that you are being bound by those conditions of probation. But again, the fact that the Commonwealth regularly requests this, just by a limited random search, I was able to find 35 examples of these kinds of quaff by 13 different district court judges in 4 different counties, 16 of which were either requested by the Commonwealth or expressly agreed on the green sheet by the Commonwealth. And so certainly the prevalence of the disposition, maybe there's a discretionary issue that you could clarify, but the Commonwealth shouldn't be able to expand its very narrow right under 29A to suddenly be having a 211 Section 3 kind of discussion here with the court about, as this court in its supervisory authority. That's my complaint with the 29A, that if they're permitted to do this here to characterize as an illegal sentence something that isn't an illegal sentence, that's
But that's your argument, right? They get to argue it's an illegal sentence, you get to argue that it's not, and then a judge says, I agree with one or the other, and then it gets appealed. So if I'm looking at the definition of a quaff, and I see that it says, as we talked to Ms. Rose about, you have to have either a period of time with conditions or a period of probation. And so the argument is, there were neither of those things here, therefore this quaff is illegal. That's what they're arguing, not that there shouldn't have been a quaff, and that's regardless of whether the Commonwealth has asked for this type of thing before or not. I'm just looking at the statute and what it requires.
Well, but I don't even think that it's quite, I mean, it certainly doesn't prohibit this. And remember, the purpose of the statute was to protect the defendant-capped disposition, the defendant-capped plea. And the language is embedded in the statute where it says the defendant can request any disposition within the judge's authority, which may include, and then I think in Sebastian, the court notes that it's not the most well-drafted statute, but then it includes this, and it does suggest, I mean, I agree that it does suggest conditions, but it also, if we're looking specifically at the language of the statute, it's only talking about the defendant-requested quaff. So that does leave open the question, so what about the judge, the sua sponte quaff? What about the quaffs that the Commonwealth requests? To say that it can only happen, this disposition can only happen with the Commonwealth's assent, is to undo the defendant-capped plea. It's to give the executive the power to veto the judge's sentencing discretion.
But again, that's your argument, and I understand that there's 2 arguments here. Why wouldn't we just decide whether the Rule 29 motion is allowed or not?
One other reason is because can a motion to revise or revoke filed 58 days after a case and all the charges have been dismissed, all of the committed portions of the sentence have been, can it reanimate that at 58 days when the Commonwealth didn't say boo, a word of objection? I mean, at a minimum, so they should have objected like they should have done so in Resende. They could have asked the judge to stay to seek this court's review. there were mechanisms, but I now really understand your question, Justice Budd. I think there's Galvin is another case, I think it was prior to Solovka, but the way the court put it is it's an allegedly illegal sentence, and that was decided under 211.3. But given everything about the Commonwealth's argument is about the exercise of the, I understand that they say it's illegal, but then you look at the substance of their argument, and it's all about the exercise of the judge's discretion. And if it's about the judge's discretion, then this is a supervisory question. It is not an illegal sentence. That's that part. And I'm sorry, Justice Seifer, you'd asked us something, and I've now.
I said maybe Brandano wasn't such a bad thing.
Oh, right. Well. So the thing I'd want to remind the court about is that many of the cases were decided about pre-plea dismissals. Brandano was pre-plea. Cheney, Manning, Peterson, Quispe, Saddlemeyer, Sebastian, Tim T. If you're drawing from teachings from those cases, then you're drawing from cases where a judge dismissed the case or a charge prior to a plea finding or verdict. And that really changes the dynamic of this court's review of that Article 30. Once you get into the post-plea, post-verdict, post-finding dispositions, it is very different. And I would respectfully disagree that it's a gag when I think what's ephemeral is the notion that you're going to hold it for 3 days when the defendant is going to be remaining in the custody of the House of Corrections. I could talk more, but I think my time is up.
We know you could. But thank you.
Thank you.